My name is Ashley Mosley, and today I'm going to talk about indecent and obscene material. The main difference between indecent, and obscene material is that obscene material is not protected by the First Amendment. Indecent material is protected by the First Amendment simply because it's considered to be less graphic and less offensive than obscene material. The definition of obscenity is taken from the Miller v. California case of 1973. Obscene material contains a patently offensive descriptions of sexual conduct. Patently offensive is referred to obscene acts or materials that are considered openly, plainly, or visibly offensive. Ultimate sexual acts, normal or perverted, actual or representations. The Miller v. California case of 1973 involved Martin v. Miller, who was convicted of using mass mailings to try to sell obscene materials. He sent brochures through the mail trying to sell his new book, Sex Orgies Illustrated, that had explicit pictures. After one of his brochures was sent to a restaurant, he was later convicted of a misdemeanor for knowingly distributing obscene material. That's when the definition was created. A work is obscene if the average person applying contemporary community standards finds that the work taken as a whole appeals to the prurient interests. The work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable law. The work taken as a whole lacks serious lapse. Lapse means literary, artistic, political, or scientific value work. The first definition of obscenity was taken from the Roth v. U.S. case of 1957. Samuel Roth was convicted for the mailing of obscene material. The Supreme Court upheld his conviction, stating that the obscene speech had no value and therefore no place in a civilized society. That's when the Supreme Court created the definition of obscene material. Material is obscene if the average person applying contemporary standards finds that the dominant theme of the material as a whole appeals to the prurient interests. Prurient interest means material that promotes lustful thoughts and urges, unhealthy interests in sex. A centaur is a person that has no foreknowledge of that they're creating a crime. In the Smith v. California case of 1959, the Supreme Court ruled that the state must prove that a seller was aware that the material that they were selling was obscene before that the state could prosecute anybody. Another case that had something to do with obscenity is the Stanley v. Georgia case of 1969. That had to do with Robert Stanley having his home raided by Georgia police looking for illegal materials when they came across his personal collection in his home of adult films. The police arrested him after they watched the films, saying that he violated Georgia's obscenity law. The conviction was overturned by the Supreme Court because they said people have the right to possess obscene material in the privacy of their own home. The First Amendment means that a state has no business telling a man sitting alone in his home that what books he may read or what films he may watch. The Osborne v. Ohio case of 1990 made it legal to possess obscene material in the privacy of your own home, but not child pornography. Child pornography is material that depicts children engaged in sexual activities, whether it is by themselves, with other children, or with adults. State and federal courts agree both child pornography is illegal because its creation involves illegal sexual exploitation of children. Child pornography does not have to be legally obscene under the Miller test to be illegal. Now we're down to indecent material. Indecent material, again, does have First Amendment protection and is considered to be less graphic or less offensive than obscene material. The goal of an indecency law is to protect children from getting access to sexually explicit material while still allowing access to adults. The indecency definition was created from the 1978 FCC versus Pacifica case. Indecent material depicts or describes in terms patently offensive sexual activities or organs at all times of the day when there is a reasonable risk that children may be in the audience. FCC versus Pacifica of 1973 basically was George Carlin created a 12-minute monologue that was aired at 2 p.m. in New York titled Filthy Words, where he was reciting the 7 dirty words that no one can say on TV or radio. Those 7 deadly filthy words are shit, piss, fuck, cocksucker, motherfucker, and tits. A man driving in New York with his 15-year-old wrote a letter to the FCC complaining about the language that they heard on the radio, and the FCC forwarded the letter to Pacifica. Pacifica replied and said, basically, we sent out a disclaimer about the program being offensive to some audiences. So the FCC did not fine Pacifica, but they kept the matter on file for, I guess, any further future incidents with them. They ruled that they had the right to prohibit indecent language during the day, though. Indecent materials should be aired at a time of the day when children are not likely to be in the audience, was said by FCC. Pacifica appealed that, ruling that the FCC has no constitutional right to regulate speech on the airways. The U.S. Supreme Court of Appeals in Washington called the FCC's ruling censorship. The FCC indecency standard would ban reading certain parts of the Bible if they basically went with that. But the NC statute 14 through 190.1 says it should be unlawful for any person, firm, or corporation to intentionally disseminate obscenity. A person, firm, or corporation disseminates obscenity within the meaning of this article if he or it sells or delivers, provides or offers, or agrees to sell, deliver, or provide any obscene writing, picture, record, or other representation or embodiment of obscene or presents or directs an obscene play, dance, or other performances, or participates directly in that portion thereof which makes it obscene. That's all I got.